So differentiation, remember now, this is if a distinction is made on a ground not recognized in the Constitution, and that you also can't read into the Constitution. So, so-called mere differentiation, no prohibited ground involved. There are two examples from Constitutional Court cases. From both of those, you will see that you can't find a prohibited ground there. But you distinguish, in the first example, you need to distinguish between owners of land in fire controlled areas and owners of land outside of those areas. There's no prohibited ground there that you can find in section 9.3, or where you can use a dignity test to recognize a ground. Same with the USTA case. There's a distinction to be made between employees who injure themselves in the shop, or clients or shoppers who injure themselves on the premises. Section 9.3 is not involved, and you can't use the dignity test to recognize any other ground. Then the so-called rational connection test applies. I'll revisit this in class as well. So the next step then, if you recognize, or if you establish that a particular situation amounts to discrimination, then you still have to consider whether it is fair or unfair discrimination. In Harkson versus Lane and a few other Constitutional Court cases, a number of factors have been identified to use to decide if a particular form of discrimination was fair or unfair. Take that first one, the impact of the discrimination. The more severe the impact, the more likely the discrimination will be unfair. The position of the complainant in society. If the complainant belongs to a vulnerable group in South African society and is now burdened with even more discrimination, that new discrimination would also be more likely to be unfair. Or if you are a victim of past patterns of inequality and you are now again saddled with discrimination, that would also be more likely unfair. The nature of the discrimination, that would depend on the particular situation. So a school could possibly discriminate on particular grounds not open to a university. For example, perhaps possibly a dress code or a code of conduct relating to your hairstyle could perhaps be open to a school and not to a university, as an example. Or a religious institution, a church, could perhaps be allowed to discriminate on particular grounds, while we do not allow any other institution to do the same. I'll point out a few more examples in class as well. And then the purpose of the discrimination. In other words, you would ask someone, why do you have this rule in place? And if it makes sense, if there's a proper purpose behind the discrimination, that could be an indication that the discrimination is fair. In a particular case, you need to look at all of these factors in combination. You don't just cherry pick one or two that suit your case. You need to look at all of these factors in other words, put all of them in the basket, compare all of them, what the likely outcome of the case would be. You cannot only choose the factors that suit your case and ignore the others. You look at all of these in combination. You could also refer to the Equality Act, the Promotion of Equality and Prevention of Unfair Discrimination Act, or PEPUDA. Section 14 of that act contains even more factors to consider in a given case to work out whether discrimination was fair or unfair. We give you one example there in the Walker judgment. In that case related to rates and taxes in the middle 90s, that the Tshwane Metro used a so-called flat rate in Mamelodi and Atteridgeville, and used a consumption-based rate in what could be termed as Old White Pretoria. The Constitutional Court said that system was at that point fair. At that point, Mamelodi and Atteridgeville did not have meters, and the level of services that were available in those areas were not comparable to what was already available in White Pretoria, and that it was fair to cross-subsidize, to ask the residents of Old White Pretoria to pay according to actual consumption, to make available funds, to over time improve the services in Mamelodi and Atteridgeville, that was acceptable and fair discrimination. At that point, however, Tshwane only sued defaulters in Old White Pretoria and did not sue anyone who did not pay in Mamelodi and Atteridgeville, and that the court said was unfair. That Tshwane had to carefully look at the ability of residents to pay, and that if you had the ability to pay and simply did not want to pay, that you should then be sued, but that you cannot only sue residents in a particular area. How does it work that once you found in terms of section 9 that unfair discrimination took place, how is it then possible to still find in terms of section 36 that somehow the unfair discrimination could still be justifiable? Just on the dictionary meaning of the words unfair and justifiable, it doesn't seem that this will happen too often, that unfair discrimination will still somehow be reasonable and justifiable. There's one example from a constitutional court case, but that was in a minority judgment by Judge Mokgoro, where she found that when President Mandela released a number of female prisoners but not male prisoners, Judge Mokgoro held that that was unfair but reasonable and justifiable, but no other judge has ever taken that kind of approach. What is the difference between direct and indirect discrimination? In direct discrimination, it's clear from the actual wording or the conduct what specific prohibited ground was at play. So in that example, no children allowed, clearly based on age, for example. Indirect discrimination, the rule seems to be neutral, seems to apply to everyone, but what in effect happens is that a particular group is disproportionately affected. For example, the no animals allowed rule in a shopping mall will disproportionately affect blind shoppers with guide dogs. And there are two other examples given. Anyone taller than 1.8 meter may apply. That would, for example, disproportionately exclude women. Same with the second one, anybody with no childcare responsibilities may apply. That rule will also disproportionately affect women. And then the last important point, it is not ever necessary to prove intention to discriminate. That's not part of the test. We look at the outcome of a particular act or decision to work out if discrimination occurred or not. And the last point I want to deal with is section 9.2 in the Constitution, that deals with what we colloquially refer to as affirmative action. Please also take note of that Van Heerden decision, just the particular paragraphs from that decision. Again, you don't need to read the rest of that case for the exam. No harm obviously in reading the full case, but those are the only paragraphs that you need for the exam. In that case, the Constitutional Court has held that if the affirmative action measure falls within the requirements set by section 9.2, then it is not unfair discrimination and the inquiry stops there. If the measure does not fall within the requirements set by section 9.2, but it does amount to discrimination on a prohibited ground, then the normal Harkson versus Lane test applies. So in a given problem situation, what you will need to do is figure out if it looks like a specific measure was put in place to only assist particular groups based on the prohibited grounds. If it looks like a special measure take, then possibly section 9.2 applies. On the next slide, I will show you the different requirements. So if you want to test if that specific special measure fits section 9.2, you need to apply the three requirements on the next slide. If you can't fit it into those three requirements, then you need to apply the normal Harkson versus Lane test. There are the requirements, the three bullets, the main bullets. Does the measure target persons or categories of persons who have been disadvantaged by unfair discrimination? Second, second requirement, is the measure designed to protect or advance such persons or categories of persons? And the third one, does the measure promote the achievement of equality? This does not have to be race-based. This does not have to be employment-based. You will, when you go and read the Van Heerden case, you will see that he dealt with pension funds for parliamentarians, so it had nothing to do with employment. And Section 9.2 is not only concerned with race, it concerns itself with any of the prohibited grounds listed in Section 9.3, or any of the unlisted grounds as well. So any special measure, any special treatment for a particular group is potentially falls within Section 9.2. Those are the three main requirements that you see listed on this slide. You need to apply those. If you cannot fit your special measure into these, then you fall back on the normal Harkson versus Lane test. All right, we will revisit some of these measures some of these slides in class. We will also look at particular practical problems, but this is it for the for this presentation. Thank you.